Good evening. I call to order the August 27th, 2015 meeting, City of Bellingham Planning Commission. Tonight's meeting is a public hearing to consider the update of the city's critical areas ordinance. Heather, please call the roll.
Tom Grinstead. Jeff Brown. Here. Garrett O'Brien.
Here.
Phyllis McKee.
Here.
Ali Taishi, Steve Crooks, and Cerise Snow have all been excused.
Good, thank you, Heather. Just a friendly reminder to those in attendance to silence your cell phones and other electronics if you have them. We don't have any minutes to approve this evening, so just a couple announcements. The last work session on this update I was not in attendance on, so I have reviewed the video from June 4th and also reviewed the staff packet and the public comment tracker that was issued at that time. And Commissioner Brown, as a
And I wanted to disclose for the record that my wife works with the CAO day in and day out, but I did not ask her to explain it to me, nor did she. So I've kept a division there, and I don't think that I have any biases one way or another.
All right, thank you. Okay, before we get into tonight's subject matter, we'd like to extend the opportunity to the attending public to come down and address the Planning Commission, speak on any topic that's not related to the update of the critical areas ordinance. We'll have an opportunity later in the public hearing to speak on the critical areas ordinance. This would be any other topic. Looks like we're going to have one speaker. Ms. Harris.
Wendy Harris. Yes, I'd like to speak to the issue of public notice. There's been a real decline in the level of information that's provided when the city issues public notice. And it's an issue of concern, I think, for the Planning Commission, because what you want is informed citizens that can come here and tell you things, based on a good, solid understanding of the facts and the law. And if we're not given adequate information, we can't do a good job. And then people are coming in here and telling you their opinions, and that's nice, but it's not the standards you need. And the SEPA notices particularly are concerning to me, because all they say is we're going to have, that we might apply mitigation requirements, and the mitigation requirements will be what's reflected in the critical area ordinance. And that is so broad as to be really meaningless. There's going to be a public hearing on Monday in front of City Council on surplus of a water utility. And that seems like something that might be kind of important. I don't really understand. And, the public was given 5 days to look at the information, and I looked at it briefly, and it's still not sufficient for me to understand. So I've been doing this for a while, so I know that the information we're getting now is not as thorough as what we were getting in the past, and I'd really like to call this out, because it's really in everyone's interest to have informed citizens. Thank you.
Thank you for the comments. Okay, the Planning Commission held a public hearing on the critical areas ordinance update January 15th of this year, followed by a work session on June 4th. Substantial public comment has been submitted to the City and Planning Commission on this update. The public comment received prior to the June 4th work session was documented and responded to by City staff by way of a public comment tracker, which was received and reviewed by the Planning Commission at the June 4th work session. The written record has remained open up until tonight's hearing, and several stakeholders have submitted written comment that has been reviewed by the Planning Commission as well. So, I think we have a lot of content to review this evening, so staff, if you'd like to get us started, we're ready.
Mr. Chair, members of the Commission, I'm Rick Sepler, the Planning Director. I'm joined by my colleagues, Development Services Manager Kurt Nebefeld, Planner Steve Sundin, and Planner Kim Wheel. Tonight we'll present the staff recommendation draft ordinance for your consideration. I'd like to start with a couple of opening remarks to frame our presentation. First, it's important to note that in 1995, the Growth Management Act, RCW 36.70A, was amended to require cities and counties to include best available science in developing policies and development regulations to protect the functions and values of critical areas. That's the core of what we're mandated to do. And specifically, we're asked to review to make sure best available science is incorporated into our ordinance. It states further that all cities and counties in the state are required to review, evaluate, and I'll underscore this, if necessary, revise their critical area ordinances. Nothing in the legislation that's pending obligates the city to completely revise its ordinance, only to look narrowly to make sure that best available science is met. The CAO is an implementing regulation. In terms of construction, it is not part of the comprehensive plan. It implements the comprehensive plan, much like subdivision and zoning ordinances implement the comprehensive plan itself. Similarly, we have a separate review process for implementing regulations. We're required to provide them to the Department of Commerce, their Growth Management Division, hold hearings that are consistent with our code, seek public comment on those, and move forward. Typically, implementing regulations are technical documents where we take the policies contained in the comprehensive plan and apply them as tempered by law so that we can actually affect future projects themselves. In looking at this ordinance and starting the process, staff did internal review, and staff came to the conclusion that best available science was used to develop the policies and development regulations in the critical area ordinance. They brought forward a draft, and that draft dealt largely with procedural issues since they felt that those standards were already incorporated. As this body will recall, significant concerns were raised by members of the community. Those concerns are something we take very seriously. We stopped the process. As you'll recall, we stepped back to regroup and to assess the specific concerns that were raised. We also reached out to both state agencies and to organizations to assess and comment on the state of our ordinance itself. We said, independently, give us a point of view whether we are achieving best available science, and if we are not, give us those suggestions and corrections, those minor course corrections that would help us achieve it. Revisions were prepared, and as the Commission will recall, review of the public comment, the extensive public comment, was facilitated on a point-by-point basis. I think we had 130 specific comments. We went through every one of those comments themselves. Revisions were subsequently prepared. We brought them forward, and these are before you this evening. Now, I know some will assert tonight that we still need to do major structural revisions to the ordinance. However, in the opinion of the state agency charged with implementing these regulations, that's the Department of Ecology, and in the opinion of a major statewide public interest group who reviewed it both legally through their legal director as well as their policy director, FutureWise, the draft before you meets or exceeds the regulatory requirements. Now I'll stop for a moment. Could we do more? Yes, certainly. One could expand the scope of that, but that was not the charge of this revision. This revision narrowly was to look at best available science. Some will assert that public participation is deficient and there are procedural errors in it. I would suggest for a implementing regulation, the process you've been going through is entirely consistent with our code and consistent with public review. And one can't say we haven't heard from the public on this based on the volume of correspondence and the depth of thought and review that have gone through it. Finally, others will assert this evening that we're not required to adopt the DOE's recommendations. To be fair, unlike shorelines, where the Department of Ecology has jurisdictional oversight and final approval, DOE only recommends in cases of the critical area ordinance. However, if you review the record, the February 5th letter of this year on point informed us that to meet best available science, we needed to deal with the buffers on the smaller wetlands, and we'll address that more specifically on point. So I think, I guess, to conclude the introduction, staff comes before you. We believe we've crafted an ordinance that's had outside review, that meets best available science, that addresses the statutory requirements. I'm going to turn this over to Planner Steve Sundin, who will walk you through some of the specific changes that are proposed. Thank you.
Thank you. Thanks, Rick. Steve Sundin, Planning Department. I actually don't have too much to add to that. I think Rick kind of covered the points that I was going to discuss, which was, kind of go through how we got here. We've had the material available since January 15th. And Rick sort of described the process, how we got here. The one additional thing is that when it looked like we were going, after you directed us to make changes after June 4th, we did reissue SEPA. We did a SEPA addendum. We notified the agencies and the parties of record, or people who have been commenting along the way, let them know that we reissued SEPA to account for the additional changes, which we're going to talk about tonight. The same ones we talked about on June 4th, essentially. And then tonight, when we're finished, we're hopeful that you would make a recommendation to council for approval, so that we continue to move this through. And of course, when we go to City Council, there'll be other opportunities for the public to come and speak and voice their concerns in front of the actual body who's authorized to give final approval. That's all I have. I'll turn it over to Kim. She's going to go into more detail about some of the more substantial things that we told you we were going to do.
Thanks.
Thanks, Steve. Did you get the memo, the August 20th memo? We had a couple of corrections to our very busy track changes version.
Yes.
Do you have any questions on those? What I'm going to do is cover just some of the main revisions, as Rick and Steve have said. The language that you see tonight in the text is exactly what we presented at the June 4th work session. So before I do that, though, we've received public comments since this packet was distributed, and I wanted to give a little bit of a background to help you when you review those comments, and perhaps even comments you get tonight. And Rick covered some of it, but so we'll start with the Clean Water Act, and I won't go back too far, but that delegated authority to the Army Corps of Engineers to regulate all wetlands. And at the same time, Department of Ecology was given authority to regulate wetlands. Subsequent to that, state legislation was passed that gave authority to Department of Ecology to regulate wetlands and to provide jurisdictions with guidance on making sure that we were consistent with the Clean Water Act. And then, about 20 years later, the Growth Management Act was passed, and again, Department of Ecology was delegated the authority to uphold the Clean Water Act, but basically through state legislation. And in addition, we had to meet this new state legislation called the Growth Management Act. And Rick mentioned the best available science piece of that. The reason I bring that up again is because DOE has taken that role and provided guidance to all these jurisdictions around that are subject to the GMA. And we have always looked to their guidance documents, best available science, for the development of our ordinance and for the changes that we're making. So the 2005 ordinance, the original critical area ordinance, was based on a model ordinance that they provided. It kind of was in the parameters of their performance standards. So our buffer widths, our categories, the mitigation ratios, things like that are all based on what we tailored a little bit for Bellingham, but based on Department of Ecology guidance. And we did the same this time. Well, we didn't start that way. We started again with a small scope, but after we got that February letter from Department of Ecology, we made some changes. And that is one of the main changes based on that letter is what I want to talk about tonight. I should add that in this cycle of critical area updates that many jurisdictions are doing, Department of Ecology did not advise any new buffer widths. And expressly said they are not proposing any new buffer widths. So our buffer widths have not changed, but I want to clarify something about what has changed. There's a document called the Wetlands and CAO Updates Guidance for Small Cities. It was published first in January 2010. And that document, their model legislation for dealing with small wetlands is that no wetland is really, based on science, without function, without importance. And so its model language says that all wetlands should be regulated except for wetlands that are isolated, category 3 or 4, which are the lower functioning wetlands, less than 1,000 square feet in size, would not be required to have buffers and would not have to go through mitigation sequencing. So we went from a threshold of about 4,000 square feet of wetlands below which we did not regulate before, category 3 and 4, and we dropped it completely down so that all wetlands are regulated. I mentioned before that Department of Ecology and Army Corps regulate all wetlands between the two of them. So this doesn't change anything about the small wetlands. If it's 500 square feet, 1,000 square feet, doesn't matter. They've always been regulated by those other agencies. We are now consistent with that guidance. And again, the buffers for those, there are no buffers. They do have to have mitigation, and but they don't have to go through mitigation sequencing. So I wanted to kind of lay that out so you'd have that backdrop. That was the main change that we made. We worked back and forth with Department of Ecology. They, in that letter, made 3 comments on what they felt would be changes we needed to make to be consistent with best available science, and that was one of them. That language is on page, 36 in your packet. And this is one of the changes. If you don't mind turning to that page, just because I know it's been a little confusing to some people who've been reviewing this, some of the public, is the new language is in bold, and NL stands for new language. And number 2 on that page, so it would be B2, starting with category 3 and 4 wetland, that section has been crossed out. And that's in your memo that you got. Okay, looks like you are understanding that. So that's where the new language is that I just spoke about. But Kurt might be getting that up on the screen. Other changes we made based on Department of Ecology's guidance is that we made all of our mitigation ratios, and those are on page 47 of your packet, consistent with the guidance. There we go. 270, page, I'm not going in like in numerical order of code. It's on the last page of the, thank you. Yep. Right. So that section is crossed out. I hope that's clear now. And then what I was saying is mitigation ratios, we've made those consistent with the guidance. That doesn't really change anything either, because those mitigation ratios were already being met on projects to satisfy Department of Ecology and Army Corps requirements. We clarified our minor critical area permits, and that's on page 20 to 24. While it appears that there's a lot of changes, there's not really. We changed that from exemptions, which didn't make sense to anyone because they're not exempt, to minor critical area permits. We improved the clarity of the language. Department of Ecology asked us to do that. We thought it was better now too. And we did one more thing. We took out essential public facilities from that section. And it's its own section now, and that's on page 24 through 25 of your packet. So what that means is the requirements for essential public facilities, I think, have been clarified a little bit. They're a type 2 permit, so the decision is one that would be noticed to the public, and it's not a minor critical area permit. Criteria remain the same. Those are the major changes. We made some other minor ones. These are the ones that sort of, there's a couple changes that we didn't make that Ecology recommended, and you can see in their letter today. Those, if you wish to ask questions about those, I can answer questions. And then maybe as a public comment, we can go over those things. Those are Steve, do you have any other? Okay. Those are what we call the highlights.
Thank you. Okay, I think if that's just a recap of staff's presentation. Of course, a lot of this information was covered on June 4th. I I think we should just do a quick, clarifying questions before we take public comment. If there's any questions regarding these most recent changes, that's probably now's a good time to ask them. I did have one question on, one of the more significant changes is the removal of exempt small wetlands, if I'm understanding that correctly, that those will now be regulated. The change was to bring those into compliance with DOE or Army Corps regulations. That's the most significant change since June 4th?
Yes, I would say, well, I guess maybe that's subject to opinion, but I think that's one of the major changes. Again, those were already regulated by the other agencies. What it means is if someone in the city of Bellingham wants to disturb one of those wetlands, they would need a critical area permit.
So how's that, what triggers that review? How's the difference? If it was already regulated by Army Corps or DOE, how does the change in our ordinance affect, the person making the application?
So before, if it was just in this case, isolated wetlands are only regulated by the Department of Ecology, but it would, before that, you wouldn't have to come to the city. If that was the only wetland on the property that was going to be disturbed, you would not need a critical area permit from the city. You would still do a wetland delineation, you would still have a mitigation plan, you would still have mitigation requirements. But the only thing that you wouldn't do is a permit from the city. But our mitigation requirements and everything else would be the same. Methodology for delineation and all that.
So you essentially have to go through 2 reviews for a small wetland then?
Well, it's, the reviews are done simultaneously usually. The applicant will submit all the wetland information to the agencies together. In fact, they're required to, through a joint permits called a JARPA, to the Corps and Ecology if those are involved. And then they submit the application to the city at the same time. It's the same information. It's the delineation, it's the mitigation plan, it's mitigation sequencing. So all the information's the same, it's gathered the same. Really the only difference, and we coordinate with the other agencies. So the outcome is the same as well. There's a local review now, and then we can track these things as well.
Jeff? Thank you.
So just to follow up on that, if this is pulled more formally into the purview of the city, does that change the relative role of ecology versus the city in the smaller wetlands? For example, I guess what I'm saying is, does that actually save people work because they're dealing primarily with the city in the context of an overall permit rather than dealing with the Corps or the ecology specifically for those small isolated wetlands? Does it actually save anything, or is it still all paperwork is going to all 3 agencies or all 2 agencies?
I think it's easier for applicants to work with a local agency because they can come in and see us, we can meet with them. I don't know what it is on their end really, but I think it would be, I don't see any really duplication or extra work necessarily. If all the information that they gather and present is going to be the same for all the agencies. So I don't know if it's probably going to be about a wash, but we'll have to see.
Well, yeah, so the idea from, staff's perspective is that it could be confusing if somebody reads in our critical area ordinance that there's an exemption on a wetland, they make a decision on a piece of property based on the exemption that they think is there was not really applicable. Making it consistent with the state and federal regulations, eliminates, misleading text in our ordinance. Is that accurate?
Well, it's not called an exemption. It just says that the wetlands, excuse me, the following wetlands are exempt from buffer provisions. It's just the buffer provisions. It's business as usual pretty much, except that 4,000 square feet dropped out. So it's now like all wetlands, but most projects don't have just small wetlands. I don't know how to explain it, but most projects have a variety of wetlands, bigger wetlands, those that are left, those properties that are left to develop usually have, so it's not usually small ones, but let's say it was. It adds the step of getting the permit from the local jurisdiction, which is the city. So they're exempt from buffer provisions and exempt from mitigation sequencing, but otherwise, it's the same.
Good, thank you. Anybody else? Phyllis?
Well, I was just going to ask more specifically, from the point of view of the person doing the construction, does this add a layer of paperwork and a layer of costs that they wouldn't have had otherwise prior to this change?
The thing we have identified is definitely they would have to get a permit from the city, and so there's that cost. But the methodology, the plans, the data that have to be presented are all the same, because everyone uses the same methodology and has the same requirements. So they would be meeting with the city on their project, and that would be another component of it. It would be submitted to all the agencies at the same time, is usually how it works. So the addition is really just the permit and the cost of the permit. And then also, we would do the monitoring of the mitigation, unless they went to the mitigation bank. So there would be that too.
Do we have any idea what, I mean, I suppose it's a ridiculous question to ask about what the added cost would be for somebody, or the added time delay? Or is there anything there that would slow people down or cost more? I'm thinking of housing costs.
Right. I don't know. We haven't done that analysis. There's any project, any property that has a wetland on it and that has, subject to our code or the other codes, has that layer of review and requirements. How many properties this affects, we haven't analyzed that. I don't think it's a huge number. Mm-hmm. There's a cost. Our critical area permits are $1,063. Small wetlands require small mitigation, so it would have been required anyway by the Department of Ecology or the Army Corps of Engineers, the Department of Ecology. They regulate isolated wetlands.
The wetland delineations are typically the most expensive. You have to go out and pay a certified biologist to go out and kick the tires and dig in the dirt and see what's going on, and that's required for DOE and Army Corps permits already. So that's not being added additional. So it really comes down to the cost of the permit, $1,000 and change. When people are filling wetlands, regardless of the size, they're still going through SEPA review, so that stays the same. And that's the opportunity we use to notify the other agencies and coordinate and, kind of talk about what the project is and how mitigation might be assessed, such that we're all in alignment. So it does allow us to coordinate so that as a builder or someone who's in the development industry, they're essentially getting the same end product from all three agencies, and that can be helpful for people also.
Thank you.
I wanted to add two things. One is whenever there's a wetland fill and mitigation occurs on the site or another site, rather it doesn't go to the bank, then the city does require 5 years of monitoring and maintenance. And so that is a cost as well. That's for all wetlands. Those are also, the other agencies don't require that. They require that you meet the performance standards, but we want that assurance that it will be met. The other thing is that there's ways to avoid small wetlands. Unless it's a very small property, usually avoidance through design can occur, and I think that's what we see usually developers trying to do, because this does add costs, but it adds avoidance is like the first line of defense, really. And so usually a small wetland, on a big property, it can be avoided.
I just had a follow-up on Phil's. Under the way the ordinance is currently written, if those exemptions were in place, does a city like Bellingham have the right to have lesser regulations than Department of Ecology and Army Corps? What would happen if an application was made today as it's currently written and there was a 500 square foot wetland identified on a single family parcel? Would they not have to do any review through?
Oh, so today, if this change hadn't, as it is today,
Yeah.
It is the applicant's responsibility to contact the agency. And if the project, like Steve said, if it has SEPA review, then that's kind of one of their notifications.
But like smaller project that wouldn't require SEPA review.
Okay, so if it's going to be any wetland that's disturbed triggers SEPA review, any wetland, regardless of size. So right away, if there's going to be a wetland disturbance, then we do issue SEPA. on that.
Okay.
But it's we notify through, as we're required to do, through SEPA, but otherwise it's the applicant's obligation to do that.
I see. Okay. Anybody else?
So, yeah, I've got one question. Am I way out in left field in assuming that a local agency using the same criteria for JARPA or DOE could come in easily on the timeline that those other two permits came through? In other words, I'm asking, is the city's permit process going to extend beyond what would happen with DOE or a JARPA permit?
Not usually. We have regulatory reform, we have our timelines we have to meet, and, not usually, no. I also want to remind everybody, remind ourselves that the guidance is, one of the things, I just want to read this one sentence in from the guidance provided by Department of Ecology. The scientific literature does not support exempting wetlands that are below a certain size. While we recognize an administrative desire to place size thresholds on wetlands that are to be regulated, you need to be aware that it is not possible to conclude from size alone what functions a particular wetland may be providing. What they're saying is that size doesn't determine what how a wetland is functioning, and therefore there's no scientific literature that supports exempting wetlands based on size. And we have, like we said before, we want to be consistent with best available science. We want to follow the guidance of Department of Ecology.
If I might follow up on that, I think that's the case in point. Some have raised comment that Department of Ecology isn't mandating you do that. However, any third party could take that section of their manual and appeal this ordinance and prevail.
Okay, I think we'll open it up for public comment. There's a request to extend the public comment period to 5 minutes this evening. If I could just take a show of hands of how many people are going to speak tonight. I think I have 7 people signed up. Is there? Okay, yeah, I think we'll do that then. We'll go 5 minutes on the public comment period, and the first speaker is Linda Twitchell.
I'm Linda Twitchell with the Building Industry Association. And let's see, I wrote you a letter. I'll try not to repeat too much of that. Our concern is the point we've just been discussing, the fact that we're doing away with the size-based exemptions that are in the current ordinance. Just for a note, I was looking at other CAOs. Everett, for instance, offers $1,000 to $4,000 or 1 to 4,000 square foot exemptions in all 4 categories of wetlands, and maybe the state just hasn't caught up with them yet. I don't know, but this is not unheard of in other cities. The main point I want to make, however, is that doing this is going to add costs. I asked today a group of our members, what does it cost for mitigation? The answer I got is, on average, about $5,000. If you, for instance, are dealing with infill, which is a concern we've been discussing a lot, and we're not talking about a larger project, but a smaller project, the small isolated wetlands could be anywhere on it, could become a problem. You used to be able to fill it and go ahead. If we can't now, and you have to mitigate, and then let's say you have to go to the Lummi Bank, 1,000 square foot fee at the Lummi Bank is $6,870. It has to be, I found out today, it has to be paid up front once you apply. Then you try and get your building permit. So you don't have a guarantee even at that point that you have a building permit. This is the concern I'm hearing from our members, is this type of thing. That the steps involved in mitigation and so forth, that this is going to cost a lot more money, put expenses on housing. Now, this is a toughie, but what we're looking at here is the language proposed by staff in the guidance document from Department of Ecology is safe language because by definition, ecology is saying this is best available science. And what happens if somebody doesn't agree with it is they challenge the city's compliance with the Growth Management Act based on the GMA's requirement that you've got to delineate and protect wetlands based on their compliance with best available science. However, the city can also be challenged in terms of compliance with the Growth Management Act on whether you are meeting all of the 13 goals that I'm sure you've heard of before in the Growth Management Act. One of them is protection for the environment. One of them is urban growth. One of them is creating enough density that you're able to avoid sprawl. One of them is housing. One of them is property rights. Each of these is supposed to be getting equal weight and attention. So we've got a situation here where you're not supposed to be supporting housing at the expense of the environment, but you're not supposed to be supporting the environment at the expense of any of these other goals, which include housing. The goal regarding housing calls out affordability. It says housing, encourage the availability of affordable housing to all economic segments of the population of the state, promote variety of residential densities and housing types, and encourage preservation of existing housing stocks. So this is the type of thing we've got to balance here somehow. How do we do it? Some cities have, I put a little handout up there earlier, some cities have, oh, now I'm forgetting what it's called, reasonable use provisions. Our CAO doesn't do this, although we do have, Kim was telling me, 3 different references to this type of thing. Is it possible to look at that and see if somehow we can balance reasonable use provisions with the ecology's insistence that we don't, that we basically mitigate all wetlands? Another possibility is if you look at the letter, the February 5th letter from Mrs. Myers, she's pointing out that you shouldn't be doing exemptions based on size because size does not determine the function or value of a wetland. Okay, what does? Can we somewhere draw a line in terms of what does determine function and value of a wetlands and say this is supposed to be an urban environment? We need to provide housing. The GMA says housing is just as important as the environment. The GMA says urban growth is just as important as the environment. So how can we approach that? Basically, I think we're going to have to look outside the box to come up with a way to balance these. But our suggestion is if we can find some way to balance the requirements on the environment with what we need in terms of housing affordability, that this would be the best thing for the community.
Thank you.
Thanks.
Okay, next speaker, Ms. Harris.
Wendy Harris. I don't envy you today. You're being required to review a very technical, complicated, lengthy document that is the heart and soul of our environmental regulations. And as you know, it's not easy. And you're being given different opinions from, different places, and I can just imagine the push and pull. And so what I want to do is tell you how I would approach your job if I was a planning commissioner. And the first thing I would do is look at what is the purpose of the critical area ordinance. And the purpose of the critical area ordinance is to protect the functions and values of critical area ecosystems, which basically is a requirement to protect what exists. Whatever exists now, even though we're developing, we can't allow to impact the net ecological functions. That's it. And that is regardless of of other laws, regardless of costs. You can find different ways to kind of work with that, but the bottom line is you've got to create no net loss. And so this is what I would do. 10 years ago, the city created its critical area ordinance. And the way that you protect critical areas is through performance standards. And so I would then look and ask the city to show me, for each of these critical areas, show me how you've determined there's been no net loss from 2004, 2005 till today. What did you look at? What was your data? What was your baseline comparison to show that you met no net loss? And if the city has evidence showing they're meeting no net loss, then the planning director's right. There isn't much that needs to be done other than review best available science and state law updates. But if, in fact, the city doesn't have the evidence and can't justify how its performance standards are meeting no net loss, then this review and revision just got a whole lot more complicated, because then we have to make sure that we're enacting performance standards that are going to meet what the legal test is. Because if you get challenged, and we know you can get, the system's built so that anyone who doesn't like the results has to sue. It can be someone from any spectrum politically, liberals, conservatives, and to defend itself, the city's going to need to show it met that legal test. So the first question I'd ask is, what evidence is there that these legal standards are adequate? And when the hearings board has looked at this, they've stated that those standards, to be meaningful, have to be quantifiable. They have to be measurable. There has to be something tangible to them. What are we measuring? And for instance, when I look at what was provided for the habitat conservation areas, which is a habitat restoration technical assessment, that doesn't address no net loss. Restoration addresses past harm, restoring what was already done. It doesn't protect what already exists. And I look through this, and they put those words protect in, but this doesn't take a protection framework. And if you want to really see the difference, the same consulting firm that worked on this a few years earlier worked on a no net loss framework for the National Fish and Wildlife Foundation, and they talked about the kinds of things you look at if you want to measure no net loss. And this is a very different looking document, and this is really what's relevant to the inquiry here, and it's what's missing. Now, we're talking about state standards. And we're being told, what the staff will tell you is, we're incorporating state standards, so that's how we're meeting performance standards. But those state standards don't necessarily track the same thing. And you can't rely on them. For instance, there's been a lot of reliance on this DOE guidelines. Those guidelines are not the law. The law that you have to follow is the revised Washington Code, which is passed by the legislature, and the WAC, the Washington Administrative Code. And that is different than those guidelines, which are more informal. So that hasn't been done. There's a lot of problems here, and I'm extremely frustrated that I'm standing here and I'm only given a few minutes to talk about something that people have really mucked up and made very complicated when it really can be made more clear. So I'm urging you not to go forward and to provide an opportunity for people like me to come forward and talk to you further so that I can give you an easier framework that you can use to analyze this. When I was working with clients, what I would do is I told them, you don't need to know the answer. You need to know how to recognize issues. And here's the analytical framework you need to follow. That's what you guys need, because you're given a lot of gobbledygook. Thank you.
Thank you, Wendy. Okay, next speaker, Donna, is it Keller? Or? Okay, thank you. State your name and address for the record, please.
I have an unusual name, although if you were in Boston, everybody would have the name. Anyway, I'm Donna Kelleher, and I have a little farm on East Smith Road out in the county. And the reason that I had a whole bunch of my friends that were going to come here, but the thing is, this is the last sunny day, so as part of the harvest, and so having something this substantial that so many people care about when there's 3 planning people not here, and when it's the last, sunny day in August is like, I'd really urge everyone, if possible, to just put a hold on it, and because it's so critical, and whatever we decide here, everyone's going to have to look at it later and perhaps wish it were different. As far as this goes, I feel like there should be a wildlife biologist here. I've talked about this before, but like when, for example, someone was raised, like, how can you tell if it's a small wetland, how critical it is? Well, how critical it is, maybe, those of us in the room don't have the expertise, and I say myself included, even though I've spent, my whole life, my whole college career studying biological systems. I'm a veterinarian, but I can just tell you that even with my limited knowledge, I can see already an erosion of certain species in our area. When we first bought the land, which was 10 years ago, we had elk, and it was so amazing. And now, basically, we saw elk 10 years ago. It was like they were, and so we live on a corridor from the river, and that's what I was going to say is maybe if someone had the biological expertise, and I know of people at the university that would be only too happy to help in this regard, because I just don't see that here at all. At least maybe it's my ignorance, but so basically where a wetland is in regards to the water supply, especially, this summer, I see the animals passing through. We're right next to the Nooksack River, and the level's gone down, but all the tributary rivers have vanished this summer. And I don't know if this is going to be a trend for the future, but it has driven the animals into a different path as usual. And if you guys are interested, I can tell you more, and I have pictures. But basically, things are shifting. And I just don't know if without that scientific expertise, if people are really taking in consideration things with climate change and changes to our environment, in making these kinds of really important decisions. So maybe I'll just leave it at that. Thank you.
Thank you, Donna. Okay, next speaker signed up, Charles Law.
Good evening. I'm Charles Law from Whatcom. First of all, I'd like to acknowledge the First Nations, Lummi and Nooksack, the land that we are on. I'm looking at this Growth Management Act, and I think somebody said it was implemented in 1995. I might be wrong, but it's been a while ago. I think it's outmoded. I think it's obsolete. I think we should start looking at not growth of our species, but a growth of the species that we all depend upon. Their habitat is our survival. Now, we can stand here, we can sit, and we can think, well, how does that affect my livelihood? How does that affect home ownership? How does that affect development? I'm sorry, folks. All those are out of the question now. You can sit there, and you can sit there, and you can think, how can I make a buck on this? How can I keep my job doing this? It ain't there anymore, folks. It's gone. If we lose our habitat, which you guys are eating away every day with your plans, your ideas, we lose the habitat, we do not survive. Somebody mentioned climate change. Somebody mentioned best available science. Well, I'm looking at best available science. 94% of the scientists in the world, the IPCC, have stated if we don't get off our butts, we're all doomed. Now, that's worldwide. we're thinking just, hey, this is just a local issue, right? Well, somebody mentioned the Army Corps of Engineers. I remember back in the 50s when the Army Corps of Engineers engineered a river in my neighborhood just for farming, destroyed the habitat, the function of the people that lived in that area. Their livelihood was totally destroyed. It was farming for them, or it was the highway. Now, a lot took the highway. Now we're sitting here and we're thinking, we can do better. We can rely on that agency. We can rely on the DOE. You only have yourself to rely on. You can't rely on someone that has their eyes clouded with gold and silver. We've done that before. We've done that before. We've had our rushes. We've had our gold rushes, silver rushes, coal. You guys know all about it. It's the heritage of Whatcom County. It's all over, folks. Suck it up, suck it in. It's a habitat for our survival. Pick one.
Thank you. Next speaker is Lily Clar. So sorry if I said that wrong. Okay, that's fine. Thanks. Okay, the next speaker. Okay, so Robert, are you okay? All right, Roger. I can't read your writing for your Almsgard. Thank you.
Excuse me, Roger Almsgard, live in Bellingham. I'm a land use consultant. I put 3 different exhibits on the bench earlier tonight, and I'll come to those in a minute or two. I want to say that I'm here because I'm involved in development. I know that's a dirty word in a lot of circles, but I don't think it is, because people do have to have decent housing to live in, and they have to have places to work and have government in also. You know, the government's affected by a lot of the overregulation that we see all over the nation. If you read some of the national news, this is going on all over the place. Too many controls on what people can do. I agree with Wendy and the others who say we have to protect the environment, but we also need what the GMA calls for, which is the word balance. I know that's trite in some folks' view, but that's what it's all about. If you read the law, that's what it's all about. There's 13 goals ranging from protect the environment through housing, economy, and private property rights, and permit process, and so on. So the critical areas is a requirement of GMA, and I think its main purpose is to protect the environment. But you know, people talk about habitat. We can't protect all the habitat for everything. We have to make some good judgment calls over which habitats that we still have are worthy of protection. Because when I talk about overregulation in Bellingham and Whatcom County, I mean that some of these buffers are too big on low-value wetlands that don't have the cattails and the great blue heron standing in them. Okay, so that's my little speech for right now. I'll just go through these handouts really fast. I think the most important one is a proposal that I've been rolling around in my mind for a few years, and that's a 2-page item that's on the bench there. The staff has it too, dated today. And as I was sitting here, I noticed a couple of mistakes in it, so I'm going to ask you to please leave the record open for as long as you want to. I'd like to submit a correction. These are not big mistakes, but I do want to fix them. And I think Wendy was supporting that idea, too, of leaving the record open for a while. I don't frankly think you need to rush this thing. I'm on the county's critical area committee, along with Wendy, and we're nowhere near finishing up. So I think the county won't be having hearings on its CAO until maybe the end of this year at the earliest. And as you know, it has to be done by June or so of next year, May or June. So my 2-page proposal here, I'm running out of time. One of my frustrations as a land use consultant and hiring wetland consultants for people on short plats, things like that, is that I think the buffers are really not based on science because they ignore site-specific conditions. You're talking about soils, slope, vegetation, existing land use, and so on. And now we have Whatcom County has applied a 150-foot buffer to all the marine shoreline from Point Roberts to Chuckanut. It just completely ignores local conditions. How can you say that's science? So that's what this piece is all about. I'm proposing an alternative, an option that applicants would have to pay their professional to recommend buffers based on actual site conditions, including what's in the immediate vicinity. So I'll stop there on that. And I ask you to please read that. We'll send a corrected version to Heather tomorrow. Another handout is people talk about growth management. They sort of ignore this section in it, 3670A.370, protection of private property. And part 2 is very important. It says local governments, such as Bellingham, are required to utilize the process established by subsection 1, which has instructed the Attorney General to prepare a memorandum on takings. And there's a link on the third handout was this avoiding unconstitutional takings. I've been in this field for a long time, and I get the impression that a lot of government officials and private citizens don't really pay much attention to law, and this is all about law. You've heard of nexus and rough proportionality. I think a lot of the rules that we're dealing with today violate those principles. Am I done?
Yeah, that's time. Thank you. Okay, is there anybody else that would wish to speak? Sir, if you could come down and just state your name and where you live for the record, that'd be great.
My name is John McLaughlin, and I essentially live at the university. I'll be giving you more detailed written comments, both to you and to council. I don't want to repeat here something like what Jeff Middow gave you earlier. I probably don't need to go through that. First, a comment about balance. The Growth Management Act requires critical areas ordinance to be developed from best available science. It applies to science. We're not talking about balance. In fact, the balance is achieved by all the other areas outside of critical areas. The scraps are what we're talking about now, left over. And I should have started with this. I would like to acknowledge that we are on Lummi historical land, and they had a completely different and much more expansive view of critical areas than we do now. We wouldn't be dealing with this kind of issue if we adopted their approach. So at first, a bit about process. I'm a little bit concerned about how we came to the draft you're looking at. As I read the description of the technical advisory group, they were asked, it says here, to invite other biologists who might not participate, but none were recommended. And hence the comment that we don't have any wildlife biologists. Mark, well, actually, I think one of them counts herself as a wildlife biologist. But essentially what you have here is recommendations from a group of consultants who make their living working with developers and dealing with critical areas. And so really what you have are people who are writing rules for how they conduct their own business. It's a little bit of an inbred process that I thank you for inviting public comment, but I would be concerned about your starting point. It's great that you got Susan Meyer and DOE folks, but you really ought to consider broader input from the start. All right, so some comments. A general theme. First, I commend you for considering the requirement for including a conservation easement. That's on page 16 of the document. That's a great addition. I wholly support that. But a general theme, though, is there are a number of exemptions and exceptions written in here which effectively compromise the function and the extent of critical areas. Again, we are now at the point where we're managing to the minimum. The expansion of urban development has reached a point we are seriously compromising the function of our landscapes. And to the degree that we compromise them further through some of these exceptions, we're going to have some very serious unintended consequences. A good example of that is on pages 10 and 11 of the ordinance, exempting essential public facilities from critical areas requirements. Well, critical areas are essential public facilities. They're some of the most important and essential public facilities. We should not give roads and other public infrastructure exemptions from those critical area review to begin with. That exemption is essentially asking government telling the rest of us that we'll make the rules and you have to follow them, but we don't have to. And that's not fair. It's also not treating the critical areas with the respect they deserve. Other exemptions might include, let's see, soil borings and percolation tests in wetlands. That's happened here, in which those have been allowed under the critical areas, and they've compromised, they've damaged the wetlands in places that were never even built upon. Areas, you're talking about boring 8 feet in diameter and 4 feet down into very sensitive wetlands with heavy equipment running all over. That should no way be allowed, and yet it was. And the ordinance should explicitly exclude that. There are a number of other exemptions and loopholes that I'll explain in my written comments later.
You wrap up your comments, John?
Sure.
Thanks.
You ought to have performance measures. The definition of mature forested wetlands is a restriction from the existing one that is going to allow destruction of more mature forested wetlands. That should be returned to the original language. And then finally, there's a lot of language in here for protecting anadromous fishes. And I would note that what you have recommended under the urban growth area expansion is going to reduce the protection of anadromous fishes. And by extension, the county's additional expansion is going to drive salmon extinct. And so all of the additional expense that people are going to try and protect critical areas is going to be for naught, because those fish are going to go extinct under the larger comprehensive plan update.
Thank you, John.
Thank you.
Okay, we've had some good comment. Is anybody else in the audience want to speak tonight? Okay, I think we'll close the public comment period of tonight's meeting and get into our discussion. But first, I'd ask if staff has any direct responses to any of the issues that were raised during the comment period.
Mr. Chair, if I might, clearly we are endeavoring to do an update that meets the requirements of the law. This is not the last time we'll be dealing with this ordinance. We will likely be before you within the next 2 years with more substantial changes. However, this is one that we've chosen to advance at this time. We feel that a number of issues were raised that are beyond the scope of the revisions that are before you. That the direction for us, again, was to review and to revise to ensure the best available science was provided. We think we've done that, and we feel that confirmation, but both DOE and the public interest group, future-wise, that we've achieved that, shows good faith. I'd ask my colleagues if they have specific responses to any of the comments that were given.
Thanks, Rick. So I'll go through and comment on things that I've noted that have come up, and then Kim will fill in kind of the blanks or fill in the other things. I think we pretty much know what each other is going to say because we've been working on this for some time. So I'll just respond to some of the things that I heard and try to provide some clarity if I can. Linda Twitchell made some good comments, and those aren't lost on us by any means, and some of you sort of hinted at some of those same things as well in terms of duplicative review and additional costs. Those are valid points. And so just so that you understand, and I said this earlier, and that is that for DOE and Corps of Engineers permits, again, folks are still paying for a wetland biologist to perform a delineation. they're still required to perform mitigation as outlined or conditioned in their permit, and that mitigation has performance standards that if they're not being met through maintenance and monitoring, they have to satisfy those, which costs money and oftentimes is still paid whether they're doing one permit or three. There's still a requirement to go out and make sure that those standards are being met. So that's an outlay regardless for a developer or for a project applicant. Where things differ is that the city, to ensure that mitigation is being satisfied, performance standards are being met, we require assignment of funds or a bond, some kind of financial surety to make sure that people are doing what they said they were going to do when we issue them permits for these types of projects. That money is slowly leaked back to the applicant or the developer as they go year by year in complete steps, so that that money is put aside, but it's not gone forever. The permit fee, of course, is an additional cost. I think it's also important to note that when we met with one of our stakeholder groups, which included qualified professionals, both geologists and wetland biologists, that we would reduce costs for projects that fall into the minor critical area permit category, which comprise about 2/3 of our critical area permits that we process. And what we did is we've created an opportunity for what's called now an evaluation. So these qualified professionals can go out, and I used the phrase kick the tires earlier. That wasn't really correct for wetland delineations, but it certainly is for evaluations where certain projects that are so small scale, a one-sheet evaluation by a qualified professional, they can provide that. Maybe it's $100, maybe it's $200, but presently those reports, when they're necessary, can cost anywhere between $500 and $1,000. So it's important to note that while the wetland change that we've made adds cost, we've already built in cost reduction in terms of reporting information, and that's something that we think you should be mindful of in sort of the greater picture. Reasonable use came up, and we don't have a specific reasonable use section in our CAO, but we do apply it specifically through the variance criteria. And we have done that in the past where important or high-functioning wetlands have large buffers, and the buffer encompasses an entire property, and that's obviously a hardship that's not a result of what someone's done or some action that they've done. And so we go through a variance process, and there's other means by which people still are able to have reasonable use of their property. One other just clarification, and that was on Mr. McLaughlin's comments about the exemptions. We're calling those minor critical area permits now, so those are laid out in section 080, and if you have taken the time to read through those, you see that they are very minor in nature. They are minimal impact, if any, in the way we've set them up and sort of framed each of those exemptions. We've done that because we don't expect there to be any impact. When people go out and provide wetland delineations or do those, they need to dig around in the wetlands to determine what kind of wetland it is and what its function and what its value is. So just to be clear, the exemptions don't allow, or minor critical area permits don't allow people to go out and destruct. It's that their actions are so small that we believe, by the way the code's written, that there will be no impact. We are still allowed to condition those, place mitigations on those types of projects if necessary. So I just wanted to clarify that. I don't have anything else at this point. Kim?
Thanks. I think you covered everything I was going to touch on, and thanks for the clarifications. I would just add that on reasonable economic use, it's also in the purpose section, and it says that the chapter should be administered with flexibility and attention to site-specific characteristics. It's not the intention of the code to deny someone all reasonable economic use, and we have applied it through variances and through this part of the purpose of the code. And yeah, I just think the clarification on exemptions, that when people do go out and do the wetland delineation, the holes they dig are by hand and are about 20 inches deep, and they cover them back in. For other kinds of infiltration tests and such, that wouldn't be allowed in a wetland. And sometimes those are required for stormwater requirements, but those would go through the minor critical area permit, so we'd have review and mitigation if necessary. And I don't think I have any other clarifications.
Just a clarification on process. There was a concern about additional comments and further to be submitted. As the Planning Commission is aware, should you make a recommendation, the record would remain open for the City Council hearing on the matter. Public is entitled to provide comment to the City Council, and there will be a notice public hearing in which they can provide testimony. So any further comments could be provided as this moves through the process. Thank you.
Thank you. Okay, we have some discussion, some questions. It's a lot of information to process here. Does anybody want to get us started on question for staff? Tom?
Well, first, I want to thank the public for their comments, and I have a question for staff. It seems that portions of the public are conflating the critical areas and the comprehensive plan. And I want to understand what the relationship between the two actually is. I know that the comprehensive plan is what do you guys call it? Policy or whatever, and the CAO is an actual implementing ordinance. But is the CAO referenced in the comprehensive plan?
The comprehensive plan sets the stage for preparing implementing ordinances, just as it identifies potential land uses, talks about future areas of the community to be developed or left undeveloped, frames parks, deals with housing. It deals with the environment. And in doing that, it sets the regulatory context for the preparation of a comprehensive plan. A review of our comprehensive plan, at least in the environmental aspect, it provides strong regulatory intent. That intent is then taken to an implementing regulation. It's not an element of the comprehensive plan.
So we can logically consider these two things separately.
You would consider the policies in the comprehensive plan, and the question you would ask is, does the implementing regulation achieve those policies and goals? That's the test of any implementing regulation. Did you take that policy base, and is it applied accurately and consistently in the critical area ordinance?
Okay.
Or any implementing reg?
Yeah. If this is kind of editorial changes to the comprehensive plan, I have a question. There's section .360, the aquifer recharge thing, and I believe right at the start it says that there are none in the city. So why do we have that in there? Why isn't that X'd out like the other one that we showed?
We're required, even if, to address those issues, even if we have none present. In essence, that's part of the framing of the Growth Management Act. Tells you those critical areas that are regulated. It's one of those areas that are protected. And if you have none, lands of agricultural significance, do we have some? I don't believe we have any designated. However, again, it is referenced in the framing legislation. So we have to address it.
So we couldn't just say after that heading, none in the city, and leave it?
You need to craft regulations. We're not, one is not 100% certain that at some future time we would not identify some small aquifer at some location. Again, it's as unlikely as it might be. It's something you are statutorily required to address.
Okay. Well, as I see it, we are actually asked to do a balancing act here between humans, which is probably the ultimate invasive species, and nature. And it's going to be tough. Now, but I do agree that with John that what we're talking about are basically the scraps of the land, the real critical areas, steep slopes or wetlands or whatever. But I'm not sure, and this is just my statement, I'm not sure that we can have a no net impact. But saying that, I also fundamentally believe, kind of like what I think the First Nations believe, that we are borrowing the land and the resources from our descendants. So we have to really protect. So that's our deal.
Thank you. Jeff?
Where to start? I have to admit I have a fair amount of discomfort here. The issue for me is that this is actually a technical ordinance, and I'm not particularly thrilled about the prospect of trying to wordsmith anything in here. This is an overlay of local authority, state authority, and federal authority, and we've received technical comment as to certain opinions about why something should be another thing, and I haven't seen it on a comment track or anything that provides a staff response as to, the legality or applicability of this proposal compared to the public comments. So it's really difficult to try to figure out what to do here. And I don't know if the best outcome on this is to forward to City Council with a request that there be a full accounting of all public comment and address each comment from the staff on a comment tracker, so there's a clear public record of what's been received in this round, not the previous round. And they can chew through it, or whether we chew through it. There are only 4 of us here. I don't know what we should be trying to achieve here tonight. So that's my concern, is I don't really know what best way to proceed, or what your other folks think about that.
Thanks, Jeff. Phyllis?
I would agree with Jeff. I feel like I'm not completely prepared to offer recommendation on this at this time. I'd love to hear from some experts. Everybody seems to be a bit biased one way or the other, but I'd love to hear, what would our choices, not only what would they mean in the future, but if we've missed things in the past, where's our benchmark? If we're already listening to, let's see, was it, I don't remember the lady's name, who was mentioning a number of the things that have happened already. Well, my question then becomes, how much of the decision-making that was going on previously affected that, and how much of it was outside the control or the jurisdiction of this kind of thing? Because if we're looking at making changes and recommendations to our policy for the city of Bellingham, we need to know whether we're dealing with like global warming. I mean, are any of these things impacting what we are hoping they would? Maybe they're not at all, or if they are, to what degree? And I'd love to hear from experts who didn't have a horse in the race, but had some real knowledge of what's going on. I would love to be more prepared.
Rick, if you want to respond to that.
If I might, if the issue is this efficacious? Is the ordinance that's currently adopted with these modifications achieving its end? That's a broader question. And there's no shortage of strong opinion on that, one way or the other. You certainly, if it's your pleasure and you need us to find folks who can address its efficacy, we'll say it's consistent with the best standards we know. There is a ongoing debate between folks who have good credentials on if it's achieving its end. And that's a much broader issue to consider. It would involve a fairly lengthy assessment of alternative points of view. It would probably need a great deal of explanation of very complex processes. I can't say that there is certainty of any one party of coming to a conclusion. What I can say, though, is sometimes, as clunky as it is, our regulatory framework is the best we have right now. And we operate in the context of what the folks who provide guidance on that tell us is in the best interest of the community. And that's what we brought before you. So any way you wish to proceed, we're happy to serve you. I'm just concerned that we may not have a debate without an end.
Mm-hmm. Thank you. Phyllis? Then Jeff?
Yes, Rick, I think if you were to go back and redefine what it is that the scope of what we're supposed to be doing right now, I feel like we're in the weeds, and I'd like to get back on the track.
The only issue in the regulations is to ensure that the ordinance that we have is consistent with best available science. That is what was mandated to do. That's one of the 4 things we're mandated to do in this update. Now, one can go back and say, oh, yes, in the original framing regulation, you need to protect the values and functions of wetlands. We believe that has been met. Now we're coming back to refine it to say, do we meet best available science? That's the narrow version of it.
How do we assure that we are dealing with the best available science? I guess that's the root of the question.
We went, our approach was to get peer review from outside the circle. We went to the state agency, who in theory is the most knowledgeable of what the state of regulations would be. They have opined, and with very minor exception, believe our ordinance is a good ordinance and achieves that end. We further went to a public interest group, FutureWise, and we asked their legal director as well as their analysts to review it and say, is this a good ordinance to achieve best available science? And they opined indeed it was. So in a sense, we are, it's not the staff's opinion, though we believe that alone. It was looking for outside guidance. Did we achieve the end? And they opined to us from the best sources we could find that we were indeed in compliance, or the provisions would be in compliance.
Thank you.
Thank you. Jeff, do you have a comment on that?
Yeah. So I guess I get back to, I guess, a better stating of my issue is that we've had good sport here over the years arguing about building heights and view corridors and articulation and all those fun things, which are all subjective. And this is an entirely different animal. You know, it seems like we're being asked to validate whether something is in fact best available science, whether the scope of the CAO revision was actually what we would support versus what we've heard otherwise. And then you've got page after page of the technical revisions. So I just have a hard time figuring out how to proceed, because I know that we've chewed up a lot of meeting time in the past over things and sent it on to council, and it, takes a life of its own, and that's where the real discussion is. So I don't know, what the best way to approach this is, or whether we can. So I guess that's what I was really trying to say in my earlier comments. I'm still kind of stuck there.
Well, my thoughts on it, and hearing from the commissioners that are here, is that there's some hesitation to make a recommendation this evening. I think, in fairness to staff and the amount of time that we've invested on this, if we don't make a recommendation, then we need to provide some clear direction on what changes we'd like to see to the draft as written, so that they could do that work. One of the things I think that I think largely from my review of this document, that the revisions do meet best available science. The city reached out to outside agencies, Department of Ecology, received their expertise and feedback. I think, in my opinion, may have gone too far on that. The Department of Ecology doesn't have to administer our city's comprehensive plan or our goals and policies. They're only looking at wetlands as in particular, the letters that we received from Ecology. So I guess my question is kind of specific to the one change that concerns me a little bit, and I don't have a clear understanding on, is the removal of the small wetland exemptions, which was a recommendation from Ecology. How when we look at our comprehensive plan and our regulations, we want to have flexibility in the administration of our codes. I don't see how removing that exemption increases any flexibility for reasonable use. And I'd like you to comment on that.
Well, I think I'd start by suggesting what reasonable use is. Reasonable use, the approach we have is avoidance. Clearly, if you could build elsewhere and not affect the wetland or the system that's protected, that's preferable. If you do have an effect, we'd look to do minimization, and there the last is replacement, and that's the least desirable. In terms of reasonable use, the courts are somewhat broad in their discussion depending on which decision you see. It has been standard practice that reasonable use is that you can build a residence on a parcel. That's typically considered. However, there's a number of questions. We had takings that were brought up. Takings are based on a number of tests. They include development-based expectations, what the rules were when you acquired the property itself in its configuration. You may have purchased property that its reasonable use is just to enjoy its view. Reasonable use is a tool we have, and in this case we use variances as a way of addressing it to try to provide some use that balances the development-based expectations on the property itself. If we're not able to do that, then we're into takings. And that can be, in cases I've worked on, very small footprints in the area that has the minimization, the minimum impact on the critical area of question. Do we need a section on reasonable use? The body of law is pretty good. We do have pretty good processes to address with it. Our variances are leading us to try to find a way through it, because it would say if your site was completely covered with critical areas, we would look and use the variance process to find the place, if any, where one could build on it. So would I advocate, should we rewrite it now? Not in this revision. That's a broader issue. Is it something we would consider in the future? Possibly. I've had good luck with establishing a section for it. But at this point, we do have a fairly good workaround.
Thanks. I guess my question would be if during the revision and update of the ordinance, if it wasn't a good time, now's not a good time to include a reasonable use provision, when is?
Well, our CAO, as we mentioned, will likely be back to see you shortly. Because we need to address some stormwater issues and other issues that are forthcoming. We see this as the first phase of revisions. We thought we would meet the requirement from state growth management early by proceeding this way, but we fully countenance that we'll likely come back. It's important to identify what we're trying to achieve and have that broader discussion when we do come back. Now, I should note that in, for example, FutureWise's recommendations to us, they grouped their recommendations phase 1 that met the scope that's before you today, and we've discussed with them all of those changes. Phase 2, which realized were beyond the scope we were considering but would merit broader discussion, and gave us a number of suggestions for a starting point. And then ultimately phase 3, which are issues that will need to be worked out through other processes. We are aware of that, and we likely would look at some of the phase 2 as we do the next iteration coming through. So can I give you dates specific? No. Can I say with this in 2 years? Probably. Almost certainly.
Phyllis?
I was just going to ask, are we aware of building lots in the city of Bellingham that this particular decision would affect? In other words, they've gone from a reliable building lot to no, you can't build on that property now. And is that considered taking if we're down zoning?
No, it would be, again, takings has a number of tests, one of which is the expectation when you purchased it of what you reasonably could do, and that's what the courts have held. So if they had a chance to build at this point, they would have an argument that they couldn't build. Now, could they build as much with changed regulations? You vest the regulations in place when you file your permit. Would this change eliminate someone from building? Probably not likely. We'd still be going through the variance process on lots to address it, what we're doing right now. So I don't think it would have a change that would eliminate someone's opportunity to build on a lot.
Okay, thank you.
I
I would just add, if we're getting down to kind of nuts and bolts, what we tell folks at the counter down in the permit center when people come in and they are inquiring about a piece of property, and we say it appears as though the entire site is encumbered by critical areas, we tell and advise folks at that point that, you know, we can't have a rule that doesn't allow somebody to do anything with the property. And so sort of the general rule of thumb is we say you might not realize all your hopes and dreams for this particular piece of property, but if we're going to take away all use, then we need to be able to, you know, essentially buy the property. And that's just kind of general terms to kind of help people understand that the intent is not to take away all reasonable use. It just might not be exactly what they were.
But again, it's based on the expectation of when you purchase it. If you buy Tidelands and come in with a building permit, you'll be denied. And the courts have held that's okay because you knew when you bought it, the regulations are long-standing that you can't build in intertidal areas.
Can I ask a specific question to get a better idea of how the small wetland, the removal of that exemption would change an application? If you had a 20,000 square foot lot zoned multifamily, or let's say single family, you want to build a house. You go in and there's on the GIS map shows a potential wetland. So you hire a wetland consultant to go out and identify the areas that may or may not be wet. It comes back at 500 square feet. Under today's ordinance as written, how does that change with that information at a 500 square foot wetland? How would that change with the red line version that we're looking at today?
Okay, I think I can answer that. Well, it depends on, are we assuming that they want to disturb the wetland? Okay.
Yeah, the only way to build on that, you know, there's 500 square feet. It's within the only reasonable footprint for setbacks. They want to build a house.
Okay, you're going to fill it. Then you would, again, you'd contact the Department of Ecology because they have jurisdiction. They always have. They would require the permitting from them and mitigation, and so would the city.
Would you require a letter or a determination from Ecology prior to issuance of building permit under the current regulations?
No, again, it's the applicant, when there's other jurisdictions that are going to be giving approvals or denials, I guess, then it's up to the applicant to contact them. Sometimes we often coordinate with them, but it seems to be sort of, all the applications are going in at once, right? Because it's a development project, so you're going to send it to the city and the Ecology and the Corps, whoever's involved. And generally, the time frame at the end of those reviews, you're issued your approvals, for example. I'm not sure if I'm answering your question, but...
Well, I guess if right now the city has no means of regulating that wetland, if it was identified at 500 square feet, there would be no means to deny a permit application as the code's written, with or without a letter from Ecology. Is that...
I see what you're saying now. Well, again, you know, we'd have this SEPA because it wouldn't be exempt from...
Family doesn't have SEPA review, does it?
Well, any wetland impact at all from anything.
So it would require a SEPA review?
Yeah, any
Okay.
wetland, any overwater work, any...
Okay.
Yeah, so that's
then,
kind of...
So then really, there's no net change
there's
to the process?
To the process, no. I think what you're asking is, would we wait to issue that building permit until we got the letter from Department of Ecology? I don't think we would practice that way because it's the applicant's responsibility to do that. We would advise them and we would do our SEPA, you know, issuance, but we would not hold up the...
Okay.
Yeah.
But this change gives the city the means to enforce and regulate a small wetland to the same measure that Ecology or Army Corps would.
Right, exactly.
Okay. All right, what do we want to do? Tom?
Well, I'm again conflicted, but I'm also kind of leaning on Mr. Sepler's indication that we'd be visiting this ordinance in 2, 3, or 4 years. So I'm I'm leaning towards recommending that we forward this to City Council.
We want to form that in a motion?
So you're suggesting that we not take any action on it, that we just forward it as is to City Council? Is that what you're saying?
Put you on the spot there.
Let me read this then.
I didn't want to know what I was voting on.
Well, I haven't made any motion yet, so.
I want to know where you were heading.
So, get to the recommendation here.
If we do get a form of a motion, of course, we can discuss as much as we want afterward.
Yeah, I guess I would recommend that, that we approve the proposed amendments and forward to City Council for their review, consideration, and approval as written and amended to date.
We have a motion. Do we have a second?
I would second that for discussion purposes.
Okay. Any comments on the motion on the table? Basically, the motion on the table is the August 27th staff report as amended and revised. No additional changes or recommendations from the Planning Commission at this time to forward this to council. Jeff?
Well, that is kind of along the lines of just passing the buck to the City Council at some level, which where I was starting. But I guess I also want to acknowledge the public comment that's come in and the complexity of it and the difficulty of trying to address the code amendments while we're still in the position of trying to make some judgment on whether best available science has been met or all these other details have been brought up. So I guess I'd just like to be really clear that we got public comment. We're trying to figure out what to do with it. There's a whole other step here, I guess, in staff addressing that, which they would presumably address when they took it to council, and not just kind of, I don't see this as a rubber stamp. I see this as here is, a technical revision to an ordinance. Here's the public comment. We had difficulty figuring out how to process that, and so here you go, council, or something like that. I don't want to just have it be like, oh, here, take it, and ignore things, but.
We would be happy to respond to the comments received this evening in testimony and pass that on as a appendices to your recommendation, if you would, so the council will at least start with staff's response to those. And I'm sure we'll have further comment and testimony by the folks who made them in front of council too. So if
okay, thank you.
Sure.
I just had a question, not to digress back, but the Lummi Mitigation Bank, if you had a project and you were to purchase, credits for land there, does that allow you the opportunity to not mitigate your wetlands? If it was a small wetland, can you essentially transfer those rights to the Lummi Mitigation Bank, or you still have to buffer and mitigate a small wetland?
If you choose, nope, you got it right. If you buy credits from the Lummi Mitigation Bank, then you're done. There's no mitigation on site. There's no you're done.
See, this is the technical aspect of it that I struggle with, because some of the best available science that I read says that the fragmentation of small wetlands is, degrading to their, function. So essentially just buying a right at the Lummi Mitigation Bank and filling in a small wetland is not really no net loss or no impact. And see, if that's available, I think a single family or a small project exemption should be allowed outright in the city. What are your comments on that?
I'm not sure that I'm following you. The concept of the bank is a much larger kind of landscape, geographically scale, you know, a larger scale.
Different function, though, than a small
Well,
wetland.
it's saying that it's, you know, we're in an urban environment. The code is set up to, you can see the purpose and intent. It's meant to have some flexibility. We know that there's going to be impacts. It shows you what you do, what you're required to do if there's going to be an impact. There's a couple avenues to deal with that, you know, avoidance or on-site mitigation or buying credits at a bank. And each decision is made based on the actual proposal. The smaller wetlands, the best available science says there's no scientific literature that says they don't have some kind of functions or value, but they should certainly have smaller and lower ones. Those ones, I think the city is more comfortable replacing at the bank in general. Because there's other criteria. They have to be isolated, they have to be category 3 or 4, and they aren't part of, you know, a priority habitat and species component. So it's those little lower functioning wetlands that don't have to have the buffers, don't have to go through mitigation sequencing that you could, and you could apply to the bank for other wetland impacts, and we've had projects recently that have done that. That's one option. And sometimes developers will package it with some mitigation on site, some at the bank. Those are all available.
Phyllis?
I would be inclined to support this particular motion, but mainly because I don't feel that we could spend a lot of time educating us to come up with, you know, an educated response. And I think, and City Council is going to have to bring themselves to that level of decision making. And so I'm thinking, yes, we may look like we're passing the buck, but it just means that they're going to have to do it anyway. And I just think that's the place to push it at this point.
Okay, we have a motion on the table. It's been seconded. There's been also direction to staff to provide a current public comment tracker to track and respond to, prior to the city council meeting, the current comments that have come in. So we have a motion and a second. All in favor signify by saying aye. Aye.
Aye.
That's 4-0. Motion passes. Okay. We're going to leave the written comment open. Yeah, yeah. The written comment will remain open.
Rick Sepler again. Clarification, we'll respond to things received tonight at this point as part of your recommendation. Okay?
I'm sorry?
Council has not set a date for its public hearings.
Yeah, I don't think there's a hearing time set yet. I guess, you know, just my thoughts kind of in closing is when we're looking at these, you know, ordinances, I think, you know, we need to look at our comprehensive plan as well, too. I think the Lummi Mitigation Bank is a good thing. However, I think that the small, you know, exemption was a good component to the ordinance as written. The challenge that I had with it, and I hope I understood this correctly, is that the only way that a person could be exempt from a small wetland is if they chose not to follow Department of Ecology protocol or Army Corps of Engineers protocol once their wetland had been identified. The city didn't have a means to enforce that ordinance, but if somebody was to act in good faith and had that knowledge of their property, the only way that exemption was really relevant was if they disregarded, you know, the regulations from Department of Ecology. So that being said, that's why I supported the motion. I would, you know, like to see if staff between, you know, now and then had the opportunity to look at, you know, recommendations for a reasonable use provision being added to our chapter. I mean, that's something that as we go forward, you're going to see ecology regulations are going to get stricter. I mean, they will. So we're going to have to balance that. And there's already a lot of constraints on our property and, you know, that's left to build on. So it's my final thoughts.
If I might, do you think it might be helpful if we had the DOE person attend the hearing for our presentation for the City Council?
Well, I think a couple comments received were, you know, a biologist explaining, you know, better explaining the functions of wetlands. You know, I think, myself personally, I think, you know, their position is well documented in the letters that they've submitted to the city. I just hope that we can maintain, you know, some balance in our, you know, ordinance, and remembering that we got a little bit of land left to build on, and it's constrained in a lot of ways. So, okay, I think we'll close the public hearing, unless there's any other discussion from the commissioners. Okay. Director's report or old or new business before we adjourn?
I think you're aware of the ongoing work on the comprehensive plan, and I think you're aware of our forthcoming open house. I think you've received materials on that. We're perfecting the exhibits as well as the topics. With your guidance, you'll have a chance to hear that before it occurs. We also will have an opportunity for the public to just provide general comment without time limit, which we could record and summarize, so issues could be summarized for you.
Good. That's good.
Thank you.
Sorry, just the ADU ordinance that was coming back
Yes,
in October? Or?
We're hoping to get that forward. At this point, we're completing a matrix. Once that's done, it'll show solutions to identified problems from a variety of jurisdictions. We'll then go back and say, do any of these work in Bellingham? And we hope to have that done and back to you in October.
Great. Okay, meeting adjourned. Thanks.